On this right to privacy, is there a right to privacy? Well, I don't know. Let's address it this way. Ladies and gentlemen, we hear the libs talk about a right to privacy in your bedroom, except, of course, when it comes to your shower head, your toilet, the light bulb, the sheets on your bed. Everything has to be regulated. The underwear you wear or don't wear, all regulated. The carpet in your bedroom, regulated by the federal government. So your bedroom is heavily regulated by the federal government. They're there all the time. Oh, yes, they are. And, of course, this right to privacy, what does it mean? Does it mean you have a right to have sex with underage children in your bedroom? To rape, to murder, to produce drugs in your bedroom? Is your bedroom special in that respect? No. What this is intended by the left to mean is abortion. It's always been intended to mean abortion. Not contraception, but abortion. And I'm going to prove it to you. Because it wasn't first the Griswold case. It was another case before the Griswold case called Poe versus Ullman in 1961. But let's listen to George Stephanopoulos, Clinton hack, Democrat hack, how he tries to take over this debate and tries to paint these candidates as nut jobs, when in fact he's the nut job, and an ignorant one at that. So from Saturday's debate, here's a montage of the contraception question. We didn't even include all of it. Cut 3, go.
Governor Romney, do you believe that states have the right to ban contraception, or is that trumped by a constitutional right to privacy? Do you believe that states have that right or not? If you accept the Supreme Court decision finding a right to privacy in the Constitution, should that be done in this case? You've given 2 answers to the question. Do you believe that the Supreme Court should overturn it or not?
All right, now let me help you, Georgie, even though none of this will matter to you. But I'll use you as the foil that you are for the greater audience. And I explained this in my book, Men in Black, in 2005. It's way above George's reading comprehension level. Now, folks, I really want you to stick with me on this. I know our critics always say all the hosts are alike, all conservative radio. It's not true. We're all honorable people. We're all patriotic people. But we have our different strengths and weaknesses, our different personalities. The modern argument for a right to privacy didn't begin with the Griswold case. It began in 1961. 1961, in Justice John Marshall Harlan's dissent in a decision called Poe versus Ullman. Now, the case was brought by Planned Parenthood on behalf of a carefully selected group of people, a married couple, a single woman, and a Planned Parenthood obstetrician, C. Lee Buxton. The Planned Parenthood suit was directed against a Connecticut law that prohibited the sale and use of contraceptives. But here's the problem. The law was never enforced. And the Supreme Court dismissed the case because the law had not been enforced against these very people in the Planned Parenthood case. So in other words, they were trying to bring a case that didn't have any merit because the contraception law was an old law that had not been enforced. So why were they trying to get this in front of the Supreme Court? It's a basic judicial principle. There has to be an actual legal dispute to be adjudicated. But it didn't stop Justice Harlan, who issued a dissent. A dissent in a case where the litigants had no standing. And he said, among many other things, quote, I believe that a statute making it a criminal offense for married couples to use contraceptives is an intolerable and unjustifiable invasion of privacy in the conduct of the most intimate concerns of an individual's personal life, unquote. But there weren't any invasions of privacy. So the first case was Poe versus Ullman in 1961, and the majority of the Supreme Court threw the case out. Planned Parenthood brought it. The ACLU was their lawyer. Because none of the people claiming that they had been harmed had been charged with anything. This old law banning contraceptives had not been enforced. And yet Justice Harlan, John Marshall Harlan, he wanted to make an issue out of this. So he said in his dissent, as I said, that To make it a criminal offense for married couples to use contraceptives is intolerable, unjustifiable invasion of privacy, and the conduct of the most intimate concerns of an individual's personal life. I wonder what he thought about sex with a goat in the bedroom. But that's a completely different point. You see, you follow the left's logic right to its end, and you'll lose your mind. Harlan provided an extensive rationale for his position, which became the theoretical cornerstone for the right to privacy. Where did Harlan derive his notions about privacy rights? Melvin Wolf, W-U-L-F, a lawyer for the American Civil Liberties Union, claims credit for first raising the idea with Harlan in the ACLU's Friend of the Court brief in Poe v. Ullman. Wolf later explained his strategy for getting the court to adopt the privacy rights approach. Now remember, privacy rights approach was aimed, in the long run, at abortion, not contraception. He said judges dislike breaking entirely new ground. If they are considering adopting a novel principle, they prefer to rest their decision on earlier law if they can, to show that the present case involves merely an incremental change, not a wholesale break with the past. He said constitutional litigators are forever trying to persuade courts that the result they are seeking would be just a short step from some other case whose decision rests soundly on ancient precedent. Since the issue of sexual privacy had not been raised in an earlier case, we employed the familiar technique of argument by analogy. If there's no exact counterpart to the particular case before the court, there are others that resemble it in general, and the principles applied in the similar cases should also be applied, perhaps even extended a little bit to the new case. So in other words, Wolf understood the court would be open to rewriting the Constitution by pretending to uphold it. Although Harlan's was a minority opinion and had no immediate legal effect, its impact would soon become clear. After Poe was decided in 1961 and thrown out, Planned Parenthood officials hatched another scheme. They found a way to get arrested so they could mount another challenge to Connecticut law. So in 1965, William O. Douglas, Justice, adopted Harlan's reasoning in the majority opinion in the Griswold versus Connecticut case, and the right to privacy became constitutional law. Now, Douglas came up with one of the most parodied phrases in Supreme Court history. In order to strike down the Connecticut law prohibiting the sale of contraceptives, Douglas wrote that, quote, specific guarantees in the Bill of Rights had penumbras, formed by emanations from those guarantees that help give them life and substance, unquote. So what does that mean? To pull out your dictionary when reading Griswold for the first time, a penumbra is an astronomical term describing the partial shadow in an eclipse or the edge of a sunspot. And it is another way to describe something unclear or uncertain. Emanation is a scientific term for gas from radioactive decay. It also means an emission. So Douglas's decision not only found a right to privacy in a penumbra of an emanation, he also manipulated the facts of the case, as leftists are wont to do. You see, Estelle Griswold, after whom the case is named, the executive director of Planned Parenthood League of Connecticut, and Dr. C. Lee Buxton, the group's medical director, gave information and prescribed birth control to a married couple. And by the way, Griswold and Buxton, not the married couple, were later convicted and fined of $100 each. In other words, they were thumbing their noses at the cops. Come on, come and get us. Look what we're doing. Look what we're doing. We need standing. Look what we're doing. So the relationship at issue then was doctor-patient, not husband-wife, just to be specific. But Douglas framed his opinion around a presumed right to marital privacy, when it had nothing to do with marital privacy whatsoever. And he went on at length about the sanctity of marriage, but used vague phrasing to describe the rights at issue, never explicitly stating that married couples have a right to use contraceptives. The law didn't outlaw that at all. He even raised the ugly specter of sex police, though no police had intruded anyone's bedroom. Not then, not ever. Now, there's a little more to this story of the Griswold case, since ABC News, and particularly George Stephanopoulos, is obsessed with it. But it's important that you know how these people use the law and manipulate it to their ends as well. So, let me just pull back a second. The entire nature of Stephanopoulos' question was based on a myth. Do you think a state has the right to ban contraceptives? And Mitt Romney actually handled it extremely well, as did Santorum. But Romney was exactly right. States don't want to do this. What state wants to do this? And by the way, states didn't want to do it in 1961 and 1965. What happened is Planned Parenthood of Connecticut had a few left-wing activists who wanted to be arrested, and they weren't arrested. They were fined $100 each. Fine me, fine me, fine me. Okay, you're fined. $100 each. All right. Was there some problem in 1965 in getting contraceptives? Am I missing something? No, there wasn't a problem. So Justice Hugo Black, another FDR appointee who had his problems when it came to Catholics, but in any event, Hugo Black and his dissent from Griswold, he wasn't impressed. He attacked the way Douglas had turned constitutional law into semantics by replacing the language of actual rights with the phrase right to privacy. And he wrote to some extent about that. And they were normally very close allies on the court. Now, 7 years after the issue of married couples and contraceptives was purportedly decided in Griswold, the court considered contraceptives in unmarried couples in 1972 in Eisenstadt versus Baird. Stick with me. There is an end to this. Now, although we quoted Griswold frequently in the majority opinion, here we go. Justice William Brennan, one of the most activist leftists in the history of the court. Nonetheless, he found the Massachusetts law could be overturned on 14th Amendment equal protection grounds without having to rely on marital privacy rights created by Griswold. So they're searching all over the Constitution, looking for this privacy right. Oh, yes. Looking all over the place. Emanations and penumbras. Now we've got the 14th Amendment, which has nothing to do with it. But we found it right there in the 14th. We've got to get the ball pushed over the abortion line. Get it? One building block on top of the other. One precedent based on another. The hell with the Constitution. While Connecticut's law in Griswold prohibited the use of the distribution of contraceptives, Massachusetts had laws further restricting their distribution. Married people could obtain contraceptives from doctors or pharmacists by prescription, while single people could obtain them only to prevent the spread of disease. And yet single people had no problem getting them. So Massachusetts law was challenged when William Baird gave a speech at Boston University about birth control and overpopulation. And you know what he did? He wanted a problem too. He exhibited contraceptives and gave Emco vaginal foam to a young woman in the audience, both of which actions were illegal, technically. And Baird wanted to be convicted. So he was. His conviction for showing contraceptives was overturned by the Massachusetts Supreme Judicial Court on First Amendment grounds, so distribution was the sole issue before the U.S. Supreme Court. But Brennan found that the statute was a prohibition on contraception per se, and he ruled whatever the rights of the individual to access contraceptives may be, the rights must be the same for the unmarried and the married alike. The problem was the unmarried and the married alike were able to get contraceptives, and but for the conduct of Planned Parenthood and some of these other activists, nobody would have been fined, nobody would have been arrested. For some reason, they wanted these cases in front of the U.S. Supreme Court. What was driving them? Condoms were abundant. What was the problem? Brennan then argued for expanding the right of privacy. He said if under Griswold the distribution of contraceptions to married persons cannot be prohibited, a ban on distribution to unmarried persons would be equally impermissible. Okay. So in other words, Douglas's rhetoric in Griswold about the sanctity of life was essentially now irrelevant. The right of privacy belonged to individuals, not the couple. Okay. Now where are we going with it? So Brennan continued. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child. Wait a minute. To bear or beget a child. Now that's interesting language. So the right to privacy means everything and nothing. It has no constitutional basis, no tangible form. But what is clear? The Supreme Court seized from the people the power to make such determinations. But more than that, Brennan inserted the phrase to bear or beget a child in the opinion. The case was about contraceptives, which affect only the begetting of children, not the bearing of children. Brennan explicitly added the concept of bearing a child as well. He was subtly laying the foundation to extend the right of privacy to encompass the right to abortion. How do we know this? This occurred at a time when Roe v. Wade, a case involving abortion, had already twice been argued before this court. It had not yet been decided. So they knew they had to decide the abortion case. Notice how the judicial activists work, inserting a word and a majority opinion here and there, inserting a phrase and a dissenting opinion, all the while biding their time until 5 justices could be cobbled together to join the cause. Now you know the rest of the story, as the great Paul Harvey used to say. Poe, Griswold, oh yes, these cases, they were all intended to develop a line of precedent for abortion on demand. The court knew exactly what it was doing, the activists on the court. Nothing to do with contraceptives, really. Nothing to do with condoms, really. Foam, you name it, you use it, nothing. There's not a shortage of these products, and there wasn't a problem getting or using these products. Now we come full circle back to the Republican debate on Saturday on an issue that's a non-issue, a complete non-issue. Do states have the right to ban the use of contraceptives? Mr. Stephanopoulos, people vote for their representatives in states. If they want to vote for representatives in the state house, in the state senate, and for a governor who wants to ban the use of contraceptives, then they can. But they don't. The people choose their representatives. And they have not chosen representatives any time in my lifetime who would ban the use of contraceptives or enforce laws against people using contraceptives. And about half of the states also refused, the representatives of those states, to support various aspects of abortion. Most of them banned abortion on demand. The Supreme Court instituted that. You want to talk about contraceptives, which is a non-issue. A non-issue. How about if we talk about a judicial oligarchy where only 5 lawyers can set policy for an entire country, completely disrupting the constitutional scheme? What do you think about that, Mr. Stephanopoulos? Did Dred Scott not teach you anything? Did Plessy versus Ferguson not teach you anything about the power of a handful of justices? Did Korematsu not teach you anything in the rounding up of Japanese Americans upheld by the FDR court? Did that not teach you anything, Mr. Stephanopoulos? You see, tyranny comes in many forms, sir. Many forms. The 10th Amendment is not outdated. Without the 10th Amendment, ladies and gentlemen, there would have been no Constitution. Although the Bill of Rights were added later, the Constitution would not have been ratified by the states, but for the promise of this, what came to be known Bill of Rights, and the sovereignty of the states under the 10th Amendment, and the sovereignty of the individual under the 9th Amendment. 2 amendments that the Brennans and Harlans and Blacks and Stephanopoulos laugh about. There were no problems getting contraceptives in the state of Connecticut. The problem was abortion. They wanted to nationalize the issue. And the Constitution didn't say a word about it. So they create a right to privacy, which is not a right to privacy at all. Because there's so many private things the government gets involved in to obstruct you and to torment you and to coerce you. What they mean by a privacy right is the right to advance their agenda and to constitutionalize it. It has nothing to do with contraceptives. I think I've answered your multiple questions, Mr. Stephanopoulos. I just think you're too stupid to understand my answer. But now that the libs brought it up, Mr. Stephanopoulos et al., I have a question about this right to privacy. I really do. Does it apply to your government-run Obamacare? In other words, why is the government involved in my health care? Don't I have a right to privacy? Why does the government require my data on their computers or access to my doctor's data on his computers? Don't I have a right to privacy? Why do I have to tell the government what kind of policy I'm purchasing from my own health care? Maybe it's a policy that deals with things that are unique to my mental and physical well-being or a member of my family. Don't I have a right to privacy? I mean, I think we're to take this right to privacy stuff and run it up the flagpole, ladies and gentlemen. The government's in our face day and night. I mean, if I want to drive my car and inside my car, don't I have a right to privacy? Can't I use a cell phone whatever I want? Eat a McDonald's hamburger if I want to? It's my right to privacy. The hell with everything else. It's a right to privacy, is it not? And where does this right to privacy begin and end? At my front door or in my bedroom? If it's at the front door, why is everything in my house, from the toaster to the shower stall to the toilet, to the amount of water I use, to the air I exhale, we call it carbon dioxide, why is that regulated or going to be regulated by the government? What about my right to privacy? Now, my children, they're going to public school, right? Why is it the government's business what they eat? That is a privacy right between my child and me. Is it not? Oh, this right to privacy that's in the Constitution. Isn't it amazing? Apparently it only applies to abortion. Everything else they can interfere with. Everything else they can tell us what to do. They can regulate. They can tax. They can harass. Where did that come from? Came from nowhere. Oh, the right to privacy. Yes. What about it? Mr. Stephanopoulos? Can the federal government abolish, regulate my right to privacy? I don't mean abortion only. I mean all the other rights that come with privacy. Mr. Stephanopoulos? If the government doesn't have a right to be in my bedroom, for what purposes can it be in my bedroom? It seems to regulate, as I look around the bedroom, it regulates a hell of a lot that's in my bedroom. It regulates a hell of a lot that's in my medicine cabinet. Regulates a hell of a lot that's in my automobile. Regulates and regulates and regulates. Right to privacy. Tell me, does private property fall into this right to privacy? Or do we all have to have skin in the game when we redistribute wealth? Well, wait a minute. And have you ever looked, those of us who actually pay federal income taxes, you ever looked at the long form when you're making deductions? You mean we got to tell the government everything? What kind of clothes we're contributing to the Goodwill or the Salvation Army or Purple Heart? The name of our church or synagogue or mosque? How much money we're giving to them? Why is that the government's right to know? Right to privacy. Right to privacy. Can't have a flat tax, of course. Now that would protect the right to privacy, wouldn't it? You report your income, one or two deductions maybe, you pay a flat. No. We need a progressive income tax. Well, does not a progressive income tax violate your right to privacy? Right to privacy. They don't believe in a right to privacy. They believe in a big, fat, bloated, top-down, authoritarian government and all the damn tyranny that comes with it. They hate the individual. They hate self-sufficiency. They hate individuals who have independence, who are successful, because they love government. So, Mr. Stephanopoulos, back to you. Do you believe in the 10th Amendment at all? If so, under what circumstances? Do you know what the 9th Amendment says? Do you believe in that at all? Do you even know why it's in there? Who wrote the 9th Amendment, Mr. Stephanopoulos? Why is that in there? Can you tell us? Were these just afterthoughts? They just thought they'd throw some extraneous language into the Bill of Rights, the 9th and 10th Amendments. What is all this 9th and 10th Amendment stuff, Mr. Stephanopoulos? And while I'm at it, what about the 5th Amendment and the takings clause on private property? It's right there. It's explicit. Do you believe in that one, Mr. Stephanopoulos? Or how about the Second Amendment, the right to bear arms? What are you going to do? You're going to twist the language in the Second Amendment and say, they only meant a militia. Oh, I see. All those frontiersmen, all those mountain men, all those men and women, all those colonists, suddenly they were prepared to hand over all their weapons to a militia. Oh, I get it now. That was the Second Amendment. And what of the First Amendment? Only the press is free under the First Amendment, right? The right to association? No. What about other parts of the First Amendment, Mr. Stephanopoulos? Do you believe in those? While I'm on the subject, what about the Constitution generally, Mr. Stephanopoulos? Do you believe in that? Or is that a throwback written by slaveholders? Just curious.